In Airline Pilots Association versus Quesada, we'll see whether agencies must hold hearings for every person that may be impacted by an agency's regulation. The administrator of the Federal Aviation Administration, or FAA, has the authority to create or revise reasonable rules and regulations that govern certain safety aspects in the aviation industry. In 1958, FAA Administrator Elwood Quesada and FAA medical staff conducted a study to determine whether the agency should set a maximum age limit for commercial pilots. Quesada and his staff evaluated medical studies that showed that people over the age of 60 had a higher risk of having heart attacks and strokes. Many airline safety experts advocated for a forced retirement age of 60 years old. In June of 1959, Quesada published a proposed regulation that held that commercial pilots would be required to retire at 60 years old. The FAA allowed public comments on the proposed regulation, but it didn't hold any public hearings on the regulation. Under the rulemaking procedures of the Administrative Procedure Act, or APA, Quesada was entitled to make his determination that a hearing wouldn't serve a useful purpose and wasn't necessary for the public interest. In December of 1959, Quesada promulgated the regulation, and 3 months later the mandatory retirement age for pilots went into effect. At the time the FAA promulgated its regulation, there were around 18,000 licensed commercial pilots in the country. 35 pilots and the Airline Pilots Association filed suit seeking an injunction to stop the FAA from enforcing the regulation. The association also sought a declaratory judgment that the regulation was void. The association argued that the FAA was required under the APA to hold an adjudicatory hearing for every affected pilot that would be forced to retire. In the alternative, the association argued that the Federal Aviation Act required the FAA to hold a hearing so that each affected pilot could submit evidence about the regulation's fairness. The district court denied the association's request for an injunction. The association appealed to the United States Court of Appeals for the Second Circuit.